Oh, Your Honor.
Hello, are you Roberto Monreal? No, but she isn't.
No.
No, you need to.
I got excited. I saw you.
No, hi. Oh, yeah, all right, so let me explain something to you. I understand that you're his parents. He seems very young to me, but once they're charged with a felony offense, they're considered legally to be an adult.
Pause right there. This is one of those moments people don't realize until it's too late. The second an 18-year-old is charged with a felony in Texas, they are legally treated as an adult, no parental shield, no courtroom handholding. And here's the twist, if parents sit in on attorney meetings, they can be called as witnesses. That destroys attorney-client privilege. Brutal reality, right? The court isn't being cold, it's protecting the defense strategy. But emotionally, that's tough. You can feel the parents wanting to step in, and the system saying, not today.
Adult, right? So you're not allowed to come up here with him unless you're coming as witnesses, okay? But you can come to court and everything, but he's here with his attorneys, all right? And what I can tell you is this, because I know parents are concerned. We want to be involved, right? And we want to know everything that's happening. But this is what I'm going to tell you. I've been a defense attorney before, and I'm sure they'll tell you, if you're in on their meetings with him where they're discussing things, it's no longer confidential. That means that the state can call you as a witness to figure out, if they want to, what happened, what was said. So even though you're his parents, he's an adult, they're his attorneys. What I can tell you about these two attorneys, nothing's going to happen unless y'all know about it. Nobody's going to, yes.
Those are the victim's parents.
That's the victim's parents.
Oh.
His mom is in the courtroom.
Oh, hey, Mom.
There's the victim's parents.
Okay, they said they were the parents. All right.
No, I'm not his parent.
Okay, so you all need to step back. Whoa. Hi, Mom. Everything's going to be fine. All right. All right, so you want an appointment of a second chair,
Yes, Your Honor.
and that will be granted. And I'm assuming, are you retained or no?
Well, as part of the bond situation, yes. As part of the bond conditions, I am retained.
All right, so what I'm going to need to do, if you want the court to appoint a second chair, I need to get some information about his finances.
I can tell you, it was a big effort to make the bond, and I can tell you that he is.
I need to call him to see. All right. Court is calling 2025 CR 006058B, State versus Roberto Monreal. Can I have parties announce?
Nick Aguilar on behalf of Roberto Monreal.
And I'm sorry, this is just for an appointment of a second chair, State.
Understood.
All right, and are you Mr. Monreal?
Yes, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Roberto Monreal.
All right, so defense, you're asking for the appointment of a second chair?
Yes, Your Honor.
All right, if you want to ask your client questions about financial.
Absolutely, Judge. You already stated your name, please.
Yes,
And how old are you?
I'm 18 years old.
And how long have you been 18?
A month, short of a month.
Okay. And are you currently working?
No, sir.
Okay. And before you bonded out, how long were you in jail?
About 3 months.
Okay. And before those 3 months, were you working?
No, sir.
So you have no assets at all in your name?
No, sir.
Okay. And where are you living?
With my mom.
And your dad lives in
Phoenix.
Phoenix, Arizona?
Yes, sir.
Okay. I know it was a group effort to make the bond, correct?
Yes, sir.
Between your mom and dad?
Yes, sir.
And they're separated, divorced?
Yes, sir.
Okay. Do you have the funds to hire a second attorney on the capital murder?
No, sir.
Have you looked into it, or your parents looked into it?
Hiring a second attorney? Yes, sir.
Okay. Roberto, are you currently going to school?
No, sir.
Have you graduated from high school?
No, sir.
And how short are you from graduating?
3 credits away, sir.
You're currently on GPS monitor?
Yes, sir.
And how are you paying the monitor fee?
My mom is, sir.
So you can't even afford a $300 monitor fee
No,
yourself?
sir.
Okay, this just escalated. When you hear capital murder in Texas, that's the highest level, life without parole or even the death penalty on the table. That's why a second chair attorney matters. Capital cases are legally complex and procedurally intense. The judge granting that request isn't generosity, it's constitutional necessity. And notice something else. He's 18. A month into adulthood. 3 credits short of high school. Now he's facing the most serious charge possible. That contrast. That's the weight of this case.
All right. I'm going to grant the motion. I'll appoint a second chair and then state who's going to be handling this case. All right. Mr. Garahan, on this case, are you all proceeding on this as a capital murder?
I'm sorry, Judge, I don't know which one this was.
Roberto Monreal.
As in capital, I believe it was just murder and that robbery.
Well, in count 1, you do have it as a murder, a felony murder.
Correct, Judge.
All right. And then count 2 is an aggravated robbery.
Is Judge. And for the record, I was the court-appointed second chair to Suzanne Kramer before Mr. Aguilera filed his notice. So that's why I was.
Okay. All right. So I've granted the motion to have a second chair. And for the record, as she stated, he was previously appointed Ms. Suzanne Kramer as first chair and Ms. Guerrero as second chair. And that the attorney, Mr. Aguilera, was retained to make the bond. Right. So we can go off the record. So on this case, where are we? Let me see where the other cases are set.
This one was supposed to be set for a bond reduction today. That's why we were out of order.
Okay. All right, Norma, when are the other cases set?
All of them were set for today, Judge.
Okay.
Only 2 are set for today. 1 was pushed for next week because the council was out.
All right, so then what we'll do is let's get a discovery date on this one. And we'll do, because of the nature of the offense, put me at 45 days for discovery. All right, so we're going to recall it July 24th for, all right, and my understanding the complainant's family is here.
Yes, Judge.
And so, if you could move this way. To all the parents in the courtroom who are involved in some shape, form, or fashion with regards to these cases, I know that emotions run high. I thank you for not causing any problems coming up, so I appreciate that. So, I just want everybody to know that all the people involved are deemed to be adults legally by the court. So I understand that emotions can run high, but I want to remind everyone, we can't do that inside the courtroom and hopefully not outside the courtroom. Just let the legal process, sort itself out. And so to all the persons who come down who want to see something that is happening in regards to these cases, the first part of the legal process is for me to make sure that the defense has all their discovery so that if someone decides they want to go to trial, they can go to trial. It does no good for people not to have all their discovery and put them to trial, because then that's not fair. So everybody needs to have a level playing field that's fair. So
This is where viewers sometimes think, why is nothing happening? But this is actually huge. Discovery is the backbone of a fair trial. The defense must see every report, every statement, every piece of evidence. If that doesn't happen, any conviction can get overturned. The judge is slowing the emotional temperature in the room and reminding everyone, court is a process, not a reaction. For the victim's family, that can feel like delay. Legally, it's protection. Big difference.
That's what's happening today. So on all of these cases, if there are parents here today related to these cases, it's not going to trial today. It's being reset for discovery. And this case is being reset for discovery for July 24th. All right. Thank you, everyone.
Thank you, Judge. You would be excused.
Yes.
And Judge, just so you know, I'm supposed to be on a murder trial on 186 that day, but I think Mr. Aguilera can handle it.
Yes. We're just doing discovery, but thank you.
Thank you, Judge.
You're welcome.
That would be excused.
Yes.
Thank you.
That be excused.
Yes.
I was at church 2 weekends ago. Good morning, Your Honor.
Morning. How are you doing?
I'll get by. Ready, Ruby?
I am ready.
You understand?
Yes.
Okay.
Hello. How are you doing?
I'm fine. How are you?
Oh, I'm doing okay. All right. So you all ready to proceed on the motion to revoke?
Yes, Your Honor.
All right, court is calling 2020 CR 7910 State versus Ruby Caceres. Could I have parties announced for the record? State.
Your opinion for the state of Texas.
James Seeloff for the defense.
And counsel, you need to have her sign this. And are you Ms. Casares?
Yes.
Are you the same Ruby Casares who was placed on deferred adjudication in 2020 CR 7910 for the offense of assault family second offense on November 13, 2020 for a period of 3 years? Is that you?
Yes.
State?
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 41. On or about the 20th day of May.
I need a motion to revoke stamp, please.
Yes.
All right, you may proceed. Sorry.
On or about the 20th day of May, 2025, in Bear County, Texas, the defendant, Casares, did then and there failed to comply with the rules and regulations of the felony drug court, and that the defendant refused to participate with program requirements in violation of condition number 41.
How do you plead to that, true or not true?
Excuse me.
True.
How do you plead to that, true or not true? All right, did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes.
Court will find violation of
This is the turning point. When she pleads true, she's essentially admitting she violated probation. And here's what that means: deferred adjudication disappears. The judge can now formally convict her and sentence her up to 10 years. She agreed to 5. That's the deal. And notice, she waived her right to appeal. That closes the door. Fast. Plea agreements move quickly, and if you blink, you miss the consequences.
condition number 41 true. Is there a proposed agreement?
Yes.
There is, Your Honor. That is to revoke the defendant and adjudicate guilt and sentence the defendant to 5 years to this.
All right, counsel, is that the agreement?
That's our agreement, and we're going to ask for credit for time served, which means she should be out pretty quick.
Right.
She's been in that long.
Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
Yes.
Thank you.
All right.
That was the paper we signed.
All right, the court is going to follow your agreement, find you guilty, revoke, sentence you to 5 years in the prison, credit for any time served. There's an affirmative finding of family violence. There should be no harmful or injurious contact with Ricardo Casares, and the court will request the therapeutic community. It's your view the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right. Good luck to you.
Your Honor,
Yes.
just to make clear, the court, I'm asking the court to take credit for time served
No, she'll get credit for any time that she's been in custody. Now,
on this.
here's the thing. You've been sentenced to 5 years in the prison. My ruling gives you credit, but that credit goes towards the 5 years in prison. Whether you're getting some extra time from the Bexar County Jail, 2 for 1, 3 for 1, that's completely up to the Bexar County Jail. Whatever the prison system wants to give you credit for, that's completely up to them. The only thing that I can...
This is a common misunderstanding. People think credit for time served means automatic early release. Not exactly. The judge can credit the time in her courtroom's jurisdiction, but how much extra credit the jail or prison gives? That's administrative. 2 for 1, 3 for 1. That's not the judge's call. And you can see the court being careful to explain that line. Judge's sentence. Correctional systems calculate.
give you credit for is the time that you've been in custody while this court has had jurisdiction. Do you understand?
I understand.
All right, good luck to you.
Thank you, Your Honor.
Oh, wait 1 second. Yes?
The victim is in the courtroom, Your Honor. He wanting your permission to address the defendant. I don't know if this is accurate.
It's not. Who is the complainant?
Brother? Is that your brother?
All right, Mr. Casares. Here's the thing. I understand that your sister has some mental health issues. Yeah. You know, I did all I could. There's nothing else I can do for her. I sent her to felony drug court. She doesn't want to go to felony drug court. So when she's released, I'm sorry?
I appreciate that you did not release her because she's going back missing.
All right. Hey, what's the name?
Isael Dominguez Serna.
Oh, okay, I have that.
Thank you.
All right, Maciel Dominguez Serna. All right, is your client a citizen or no?
He is not.
Did you speak with an immigration attorney, or you are going to do that on your own?
Oh, no. I was spoken to him in Spanish, Your Honor. He's been referred to we consulted with him with other immigration attorneys, so he's aware of any immigration consequences to any kind of plea.
All right. And sir, how old are you?
23.
All right, this was previously set for plea deadline date, but I know you were in jury trial. So this is being reset for the week of June 23rd for a plea deadline date. At that time, you all need to make a decision of whether or not you want a jury trial, bench trial, if anything is not worked out.
Yes, Your Honor. He has been sent to PTD, and the client will be pursuing PTD, so he should be enrolled on or before, or should be on the program by June 23rd, Your Honor.
All right, Ms. Ferguson, give me a PTD date, please. All right, July 17th. Thank you.
Thank you, Your Honor.
Once you sign the reset form, you're excused. Thank you so much. Good morning. How are you doing?
Great, thank you. Thank you very much.
You're welcome. All right, Miss, where is she?
Hi, Your Honor.
Hi, so you were recently in jury trial? Were you?
Yeah, I had one up in 399, and he pled guilty. So I asked the service to try to reset it for me, and they were able to. Subsequently, but I was trying. Did I give the court the proper notice?
You did. I was just wondering how things went.
Oh, he pled.
Okay. All right. So on Adriana Ramos, before we get to bond conditions, where are we on discovery?
I've gotten some, but I don't think I got it all. It looked slow.
Yes, we're actually missing the file down here. Your Honor, I need a request from upstairs, so I can confirm that what exactly he's missing, so I can try and get it to him. Additionally, I think he's got the bond stuff that we need to call the victim on as well too.
All right. So y'all are not ready to approach. They need to call the complainant with regards to the bond.
And if I could clean up my motions incorrect. The no contact order is with respect to the man she allegedly cut. The two kids are with him. I told her, don't do anything to go get those kids because she can't have contact with him. I guess what I think is for the best is a court to order how that will be done.